Hello guys, this is Rishabh and I am legal intern in the LEXIS and Company. Today's topic is on a nuisance. What is nuisance? This is easy will attempt to explain what exactly falls under the ambit of private nuisance in the law of torts. The imprecise boundaries of what exactly constitutes a private nuisance makes the task of providing an exhaustive definition of the tort almost impossible. The presently accepted definition of private nuisance that speaks only of substantial interference and the unreasonableness is simplistic and inadequate. The article, through a focused analysis of the tort of private nuisance following from some landmark decision and other authorities, intended to clarify what kind of situations make for a valid standing or a private nuisance in a court. Requirement of a valid claim for a private nuisance. Private nuisance broadly take three forms, namely in encroachment on the land of the neighbor, direct physical injury to the land, and the interference with the enjoyment of the land by the neighbors. Collectively, the situation encompassed by the three aforementioned faults are almost infinite. It may vary from the inconvenience caused by an unpleasant noise of automobiles and the smell of the cattle to the damage caused to the structure by a vibration. But does not mean that a very slight and a trivial annoyance is enforceable. Under the tort, private nuisance, in order for a fault to qualify a private nuisance, it is must primarily interference with the use of enjoyment of one's land and must be unreasonable in its effect of a plaintiff. Other secondary requirement of a private nuisance, like a quality of recurrence are subsequently discussed in the essay. The basic objective of the law of private nuisance is, however, to maintain a series of checks and balances between the enforcing the rights of one another. It is because of this that there is no cut and dried resolution mechanism for a private nuisance. The cases of falling under the tort are therefore decided on the case-to-case basis. Though some of respects, though that need a fulfillment of an incidence to qualify of a private nuisance are substantial interference, since tort law aims to maintain a balance between the right of the occupier to the to do what he likes and the right of the neighbor not to be interfered with. It is a paramount to show leniency toward the measure of interference that stem out of a proximity between two individuals. Therefore, the situation of the interference enforceable by a law must be higher than the certain a magnitude, as Lord Sullivan stated that Gaunt versus a Fanny. Such things to be offend against the law must be done in a manner which beyond a fair controversy are to be regarded exclusive. But once again a question of whether the interference is sufficiently excessive is a question of a fact and is a different from different cases. The court have however devised the yardsticks in order to gauge the magnitude of a harm caused of a neighbor. The first is the material damage caused to the land. The kind of a nuisance that causes a material damage to the land includes a collapse of a defendant's property onto a claimant's land, drenching and the flooding from the drenching and the flooding. The second is the location of the claimant's premises. So, private nuisance and negligence, as a been stated earlier, the most fundamental area to overlap the tort and nuisances. The court may therefore reject the prayer of an injunction for actionable nuisance is approved. The may seems unfair and reading. Basically, you can say that such cases that need to be considered by weighing the veracity of a claim and substantial interference and the unreasonable institution. These factors, though essentially separate, often from a precondition of the existence of the order. Thank you very much, guys, to listening me.